Budget in Parliament. The Constitution refers to the budget as the annual financial statement. In other words, the term budget has nowhere been used in the Constitution. It is the popular name for the annual financial statement that has been dealt with in Article 112 of the Constitution. The budget is a statement of the estimated receipt and expenditure of the government of India in a financial year which begins on 1st April and ends on 31st March of the following year. In addition to the estimates of receipts and expenditure, the budget contains certain other elements. Overall, the budget contains the following. Number 1. Estimates of revenue and capital receipt. Number 2. Ways and means to raise the revenue. Number 3. Estimates of expenditure. Number 4. Details of the actual receipt and expenditure of the closing financial year and the reasons for any deficit or surplus in that year. Number 5. Economic and financial policy of the coming year, that is, taxation proposals, prospect of revenue, spending program, and introduction of new schemes projects. Till 2017, the Government of India had two budgets, namely the railway budget and the general budget. While the former consisted of the estimates of receipt and expenditure of only the Ministry of Railways, the latter consisted of the estimate of receipt and expenditure of all the ministries of the Government of India except the railways. The railway budget was separated from the general budget in 1924 on the recommendations of the Ackworth Committee Report 1921. The reasons or objectives of this separation were as follows. Number 1. To introduce flexibility in railway finance. Number 2. To facilitate a business approach to the railway policy. Number 3. To secure stability of the general revenues by providing an assured annual contribution from railway revenues. Number 4. To enable the railways to keep their profits for their own development after paying a fixed annual contribution to the general revenues. In 2017, the central government merged the railway budget into the general budget. Hence, there is now only one budget for the Government of India, that is Union Budget. Constitutional provisions. The Constitution of India contains the following provisions with regard to the enactment of budget. Number 1. The President shall, in respect of every financial year, causes to be laid before both the Houses of Parliament a statement of estimated receipt and expenditure of the Government of India for that year. Number 2. No demand for a grant shall be made except on the recommendation of the President. Number 3. No money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law. Number 4. No money bill imposing tax shall be introduced in the Parliament except on the recommendation of the President, and such a bill shall not be introduced in the Rajya Sabha. Number 5. No tax shall be levied or collected except by authority of law. Number 6. Parliament can reduce or abolish a tax but cannot increase it. Number 7. The Constitution has also defined the relative roles or position of both the Houses of Parliament with regard to the enactment of the budget in the following way. A money bill or finance bill dealing with taxation cannot be introduced in the Rajya Sabha. It must be introduced only in the Lok Sabha. B. The Rajya Sabha has no power to vote on the demand for grants. It is the exclusive privilege of the Lok Sabha. C. The Rajya Sabha should return the money bill or finance bill to the Lok Sabha within 14 days. The Lok Sabha can either accept or reject the recommendation made by Rajya Sabha in this regard. Number 8. The estimates of expenditure embodied in the budget shall show separately the expenditure charged on the Consolidated Fund of India and the expenditure made from the Consolidated Fund of India. Number 9. The budget shall distinguish expenditure on revenue account from their expenditure. Number 10. The expenditure charged on the Consolidated Fund of India shall not be submitted to the vote of Parliament. However, it can be discussed by the Parliament. Charged expenditure. The budget consists of two types of expenditure: the expenditure charged upon the Consolidated Fund of India and the expenditure made from the Consolidated Fund of India. The charged expenditure is non-votable by the parliament, that is, it can only be discussed by the parliament, while the other type has to be voted by the parliament. The list of the charged expenditure is as follows. Number 1. Emoluments and allowances of the President and other expenditure relating to his office. Number 2. Salaries and allowances of the Chairman and the Deputy Chairman of the Rajya Sabha and the Speaker and the Deputy Speaker of the Lok Sabha. Number 3. Salaries, allowances and pensions of the judges of the Supreme Court. Number 4. Pensions of the judges of High Court. Number 5. Salary, allowances and pension of the Comptroller and Auditor General of India. Number 6. Salaries, allowances and pension of the chairman and members of the Union Public Service Commission. Number 7. Administrative expenses of the Supreme Court, the Office of the Comptroller and Auditor General of India and the Union Public Service Commission, including the salaries, allowances and pensions of the persons serving in these offices. Number 8. The debt charges for which the Government of India is liable, including interest, sinking, fund charges and redemption charges and other expenditure relating to the raising of loans and the service and redemption of debt. Number 9. Any sum required to satisfy any judgment, decree or award of any court or arbitral tribunal. Number 10. Any other expenditure declared by the Parliament to be so charged. Stages of enactment. The budget goes through the following 6 stages in the Parliament. Number 1. Presentation of budget. Number 2. General discussion. Number 3. Scrutiny by departmental committee. Number 4. Voting on demands for grants. Number 5. Passing of appropriation bill. Number 6. Passing of finance bill. Number 1. Presentation of budget. Conventionally, the budget is presented to the Lok Sabha by the Finance Minister on the last working day of February. Since 2017, the presentation of the budget has been advanced to 1st of February. The budget can also be presented to the House in 2 or more parts, and when such presentation take place, each part shall be dealt with as if it were the budget. Further, there shall be no discussion of the budget on the day on which it is presented to the House. The Finance Minister presents the budget with a speech known as the budget speech. At the end of the speech in the Lok Sabha, the budget is laid before the Rajya Sabha, which can only discuss it and has no power to vote on the demands for grants. The budget documents presented to the Parliament comprise of the following. Number 1. Budget speech. Number 2. Annual financial statement. Number 3. Demand for grants. Number 4. Appropriation bill. Number 5. Finance bill. Number 6. Statements mandated under the FRBM Act include macroeconomic framework statement, fiscal policy strategy statement and medium term fiscal policy statement. Number 7. Expenditure budget. Number 8. Receipt budget. Number 9. Expenditure profile. Number 10. Memorandum explaining the provisions in the finance bill. Number 11. Budget at a glance. Number 12. Outcome budget. Earlier, the economic survey also used to be presented to the Parliament along with the budget. Now it is presented one day or a few days before the presentation of the budget. This report is prepared by the Finance Ministry and indicates the status of the national economy. Number 2. General discussion. The general discussion on budget begins a few days after its presentation. It takes place in both the Houses of Parliament and lasts until usually for 3 to 4 days. During this stage, the Lok Sabha can discuss the budget as a whole or on any question of principle involved therein, but no cut motion can be moved, nor can the budget be submitted to the vote of the House. The Finance Minister has a general right of reply at the end of the discussion. Number 3. Scrutiny by departmental committee. After the general discussion on the budget is over, the houses are adjourned for about 3 to 4 weeks. During this gap period, the 24 departmental standing committee of the Parliament examine and discuss in detail the demands for grants of the concerned ministers and prepare reports on them. These reports are submitted to both the Houses of Parliament and consideration. The standing committee system, established in 1993 and expanded in 2004, makes parliamentary financial control over ministries much more detailed, close, in-depth and comprehensive. Number 4. Voting on demands for grants. In the light of the reports of the Departmental Standing Committee, the Lok Sabha takes up voting of demands for grants. The demands are presented ministry-wise. A demand becomes a grant before it has been duly voted. Two points should be noted in this context. One, the voting of demands for grants in the exclusive privileges of the Lok Sabha, that is, the Rajya Sabha has no power of voting the demands. Second, the voting is confined to the votable part of the budget. The expenditure charged on the Consolidated Fund of India is not submitted to the vote, it can only be discussed. Each demand is voted separately by the Lok Sabha. During this stage, the members of parliament can discuss the details of the budget. They can also move motions to reduce any demand for grant. Such motions are called as cut motion, which are of three kinds. Policy cut motion. It represents the disapproval of the policy underlying the demand. It states that the amount of the demand be reduced to rupees 1. The members can also advocate an alternative policy. Economy cut motion. It represents the economy that can be affected in the proposed expenditure. It states that the amount of the demand be reduced by a specified amount, which may be either a lump sum reduction in the demand or omission or reduction of an item in the demand. Token cut motion. It ventilates a specific grievance that is within the sphere of responsibility of the Government of India. It states that the amount of the demand be reduced by rupees 100. A cut motion to be admissible must satisfy the following conditions. Number 1. It should relate to one demand only. Number 2. It should be clearly expressed and should not contain arguments or defamatory statements. Number 3. It should be confined to one specific matter. Number 4. It should not make suggestions for the amendment or repeal of existing laws. Number 5. It should not refer to a matter that is not primarily the concern of union government. Number 6. It should not relate to the expenditure charged on the Consolidated Fund of India. Number 7. It should not relate to a matter that is under adjudication by a court. Number 8. It should not raise a question of privilege. Number 9. It should not revive discussion on a matter on which a decision has been taken in the same session. Number 10. It should not relate to a trivial matter. Number 11. It should not reflect on the character or conduct of any person whose conduct can only be challenged on a substantive motion. Number 12. It should not anticipate a matter which has been previously appointed for consideration in the same session. Number 13. It should not seek to raise a discussion on a matter pending before any statutory tribunal or statutory authority performing judicial or quasi-judicial function or any commission or court of inquiry. The significance of a cut motion lies in facilitating the initiation of concentrated discussion on a specific demand for grant and upholding the principle of responsible government by proving the activities of the government. However, the cut motion do not have much utility in practice. They are only moved and discussed in the House but not passed as the government enjoys majority support. Their passes by the Lok Sabha amounts to the expression of want of parliamentary confidence in the government and may lead to its resignation. On the last day of the days allotted for discussion and voting on the demands for grants, the Speaker puts all the remaining demands to vote and disposes them whether they have been discussed by the members or not. This is known as guillotine. Number 5. Passing of Appropriation Bill. The Constitution states that no money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law. Accordingly, an appropriation bill is introduced to provide for an appropriation out of the Consolidated Fund of India all money required to meet the grants voted by the Lok Sabha, the expenditure charged on the Consolidated Fund of India. No such amendment can be proposed to the appropriation bill in either house of the parliament that will have the effect of varying the amount or altering the destination of any grant voted or of varying the amount of any expenditure charged on the Consolidated Fund of India. The appropriation bill becomes the appropriation act after it is assented to by the president. This act authorizes or legalizes the payments from the Consolidated Fund of India. This means that the government cannot withdraw money from the Consolidated Fund of India till the enactment of the appropriation bill. This takes time and usually goes on till the end of April, but the government needs money to carry on its normal activities after 31st March, the end of the financial year. To overcome this functional difficulty, the Constitution has authorized the Lok Sabha to make any grant in advance in respect to the estimated expenditure for a part of the financial year, pending the completion of the voting of the demands for grants and the enactment of the appropriation bill. This provision is known as the vote on account. It is passed or granted after the general discussion on budget is over. It is generally granted for 2 months for an amount equivalent to one-sixth of the total estimation. Number 6. Passing of Finance Bill. The Finance Bill is introduced to give effect to the financial proposals of the Government of India for the following year. It is subjected to all the conditions applicable to a money bill. Unlike the appropriation bill, the amendments seeking to reject or reduce a tax can be moved in the case of Finance Bill. According to the Provisional Collection of Taxes Act of 1931, the Finance Bill must be enacted, that is passed by the Parliament and assented to by the President within 75 days. The Finance Act legalizes the income side of the budget and completes the process of the enactment of the budget. Other grants. In addition to the budget that contains the ordinary estimates of income and expenditure for one financial year, various other grants are made by the Parliament under extraordinary or special circumstances. Supplementary grant. It is granted when the amount authorized by the Parliament through the Appropriation Act for a particular service for the current financial year is found to be insufficient for that year. Additional grant. It is granted when a need has arisen during the current financial year for additional expenditure upon some new service not contemplated in the budget for that year. Excess grant. It is granted when money has been spent on any service during a financial year in excess of the amount granted for that service in the budget for that year. It is voted by the Lok Sabha after the financial year before the demands for excess grants are submitted to the Lok Sabha for voting. They must be approved by the Public Accounts Committee of Parliament. Vote of credit. It is granted for meeting an unexpected demand upon the resources of India when, on account of the magnitude or the indefinite character of the service, the demand cannot be stated with the details ordinarily given in a budget. Hence, it is like a blank check given to the executive by the Lok Sabha. Exceptional grant. It is granted for a special purpose and forms no part of the current service of any financial year. Token grant. It is granted when funds to meet the proposed expenditure on new service can be made available by reappropriation. A demand for the grant of a token sum of rupees 1 is submitted to the vote of Lok Sabha, and if assented, funds are made available. Reappropriation involves transfer of funds from one head to another. It does not involve any additional expenditure. Supplementary, additional excess and exceptional grants and vote of credit are regulated by the same procedure which is applicable in the case of a regular budget. Funds. The Constitution of India provides for the following three kinds of funds for the central government. Number 1. Consolidated Fund of India under Article 266. Number 2. Public Account of India under Article 266. Number 3. Contingency Fund of India under Article 267. Consolidated Fund of India. It is a fund to which all receipts are credited and all payments are debited. In other words, all revenues received by the Government of India, all loans raised by the government by the issue of treasury bill, loans or ways and means of advances, all money received by the government in repayment of loans forms the Consolidated Fund of India. All the legally authorized payment on behalf of the Government of India are made out of this fund. No money out of this fund can be appropriated, issued or drawn except in accordance with the parliamentary law. Public Account of India. All other public money other than those which are credited to the Consolidated Fund of India received by or on behalf of the Government of India shall be credited to the Public Account of India. This includes Provident Fund deposit, judicial deposit, saving bank deposit, departmental deposit, remittances and so on. This account is operated by executive action, that is, the payment from this account can be made without parliamentary appropriation. Such payments are mostly in the nature of banking transaction. Contingency Fund of India. The Constitution authorized the Parliament to establish a Contingency Fund of India into which amounts determined by law are paid from time to time. Accordingly, the Parliament enacted the Contingency Fund of India Act in 1950. This fund is placed at the disposal of the President and he can make advances out of it to meet unforeseen expenditure pending its authorization by the Parliament. The fund is held by the Finance Secretary on behalf of the President. Like the Public Account of India, it is also operated by executive action. Multifunctional role of Parliament. In the Indian politico-administrative system, the Parliament occupies a central position and has a multifunctional role. It enjoys extensive powers and performs a variety of functions towards the fulfillment of its constitutionally expected role. Its powers and functions can be classified under the following heads. Number 1. Legislative powers and functions. Number 2. Executive powers and functions. Number 3. Financial powers and functions. Number 4. Constituent powers and functions. Number 5. Judicial powers and functions. Number 6. Electoral powers and functions. Number 7. Other powers and functions. Number 1. Legislative powers and functions. The primary function of Parliament is to make laws for the governance of the country. It has exclusive power to make laws on the subjects enumerated in the Union list, which at present has 98 subjects, originally 97 subjects, and on the residuary subjects, that is, subjects not enumerated in any of the three lists. With regard to concurrent list, which has at present 52 subjects, originally 47 subjects, the Parliament has overriding powers. That is, the law of Parliament prevails over the law of the state legislature in case of a conflict between the two. The Constitution also empowers the Parliament to make laws on the subjects enumerated in the state list, which at present has 59 subjects, originally 66 subjects, under the following 5 abnormal circumstances. Number 1. When Rajya Sabha passes a resolution to that effect. B. When a proclamation of national emergency is in operation. C. When two or more states make a joint request to the Parliament. D. When necessary to give effect to international agreement, treaties and conventions. E. When President's rule is in operation in that state. All the ordinances issued by the President during the recess of the Parliament must be approved by the Parliament within 6 weeks after its reassembly. An ordinance becomes inoperative if it is not approved by the Parliament within that period. The Parliament makes laws in a skeleton form and authorizes the executive to make detailed rules and regulations within the framework of the parent law. This is known as delegated legislation or executive legislation or subordinate legislation. Such rules and regulations are placed before the Parliament for its examination. Number 2. Executive powers and functions. The Constitution of India established a parliamentary form of government in which the executive is responsible to the Parliament for its policies and act. Hence, the Parliament exercises control over the executive through question hour, 0 hour, half an hour discussion, short duration discussion, calling attention motion, adjournment motion, no confidence motion, censure motion, and other discussions. It also supervises the activities of the executive with the help of its committee like Committee on Government Assurance, Committee on Subordinate Legislation, Committee on Petitions, etc. The ministers are collectively responsible to the Parliament in general and to the Lok Sabha in particular. As a part of collective responsibility, there is individual responsibility, that is, each minister is individually responsible for the efficient administration of the ministry under his charge. This means that they continue in office so long as they enjoy the confidence of the majority members in the Lok Sabha. In other words, the Council of Ministers can be removed from office by the Lok Sabha by passing a no confidence motion. The Lok Sabha can also express lack of confidence in the government in the following ways. A. By not passing a motion of thanks on the President's inaugural address. B. By rejecting a money bill. C. By passing a censure motion or an adjournment motion. D. By defeating the government on a vital issue. E. By passing a cut motion. Therefore, the first function of Parliament can be said to be to select the group which is to form the government, support and sustain it in power so long as it enjoys its confidence, and to expel it when it ceases to do so, and leave it to the people to decide at the next general election. Number 3. Financial powers and functions. No tax can be levied or collected, and no expenditure can be incurred by the executive except under the authority and with the approval of Parliament. Hence, the budget is placed before the Parliament for its approval. The enactment of the budget by the Parliament legalizes the receipt and expenditure of the government for the ensuing financial year. The Parliament also scrutinizes government spending and financial performance with the help of its Financial Committee. These include Public Account Committee, Estimate Committee, and Committee on Public Undertakings. They brings out the cases of illegal, irregular, unauthorized, improper uses and wastage and extravagance in public expenditure. Therefore, the parliamentary control over the executive in financial matters operates in two stages. A. Budgetary control, that is, control before the appropriation of grants through the enactment of the budget. B. Post budgetary control, that is, control after the appropriation of grants through the three financial committees. The budget is based on the principle of annuity, that is, the parliament grants money to the government for one financial year. If the granted money is not spent by the end of the financial year, then the balance expires and returns to the Consolidated Fund of India. This practice is known as the rule of lapse. It facilitates effective financial control by the parliament as no reserve funds can be built without its authorization. However, the observance of this rule leads to heavy rush of expenditure towards the close of the financial year. This is popularly called as March rush. Number 4. Constituent powers and functions. The Parliament is vested with the powers to amend the Constitution by way of addition, variation, or repeal of any provision. The major part of the Constitution can be amended by the Parliament with the special majority, that is, a majority of the total membership of each House and a majority of not less than two-thirds of the members present and voting in each House. Some other provisions of the Constitution can be amended by the Parliament with simple majority, that is, a majority of the members present and voting in each House of Parliament. Only a few provisions of the Constitution can be amended by the Parliament by special majority and with the consent of at least half of the state legislatures by simple majority. However, the power to initiate the process of the amendment of the Constitution in all the three cases lies exclusively in the hands of the Parliament and not the state legislature. There is only one exception, that is, the state legislature can pass a resolution requesting the Parliament for the creation or abolition of the Legislative Council in the state. Based on the resolution, the Parliament makes an act for amending the Constitution to that effect. That to sum up, the Parliament can amend the Constitution in three ways: by simple majority, by special majority, and by special majority but with the consent of half of all the state legislature. The constituent power of the Parliament is not unlimited. It is subject to the basic structure of the Constitution. In other words, the Parliament can amend any provision of the Constitution except the basic features of the Constitution. This was ruled by the Supreme Court in the Keshwanand Bharti case of 1973 and reaffirmed in the Minerva Mills case of 1980. Number 5. Judicial powers and function. The judicial power and functions of the Parliament include the following. A. It can impeach the President for the violation of the Constitution. B. It can remove the Vice President from his office. C. It can recommend the removal of judges including Chief Justice of the Supreme Court and the High Courts, Chief Election Commissioner, Comptroller and Auditor General to the President. D. It can punish its members or outsiders for the breach of its privileges or its contempt. Number 6. Electoral powers and functions. The Parliament participates in the election of the President along with the state legislative assemblies and elect the Vice President. The Lok Sabha elect its Speaker and Deputy Speaker while the Rajya Sabha elects its Deputy Chairman. The Parliament is also authorized to make laws to regulate the elections to the offices of President and Vice President, to both the Houses of Parliament and to both the Houses of State Legislature. Accordingly, Parliament enacted the Presidential and Vice Presidential Election Act 1952, the Representation of People Act 1950 and the Representation of People Act 1951, etc. Number 7. Other powers and functions. The various other powers and functions of the Parliament include: Number A. It serves as the highest deliberative body in the country. It discusses various issues of national and international significance. B. It approves all the three types of emergencies, national, state, and financial, proclaimed by the President. C. It can create or abolish the State Legislative Council on the recommendation of the concerned state legislative assemblies. D. It can increase or decrease the area, alter the boundaries, and change the name of a state of the Indian Union. E. It can regulate an organization or jurisdiction of the Supreme Court and High Courts and can establish a common High Court for two or more states. Ineffectiveness of parliamentary control. The parliamentary control over government and administration in India is more theoretical than practical. In reality, the control is not as effective as it ought to be. The following factors are responsible for this. A. The parliament has neither time or expertise to control the administration, which has grown in volume as well as complexity. B. Parliament's financial control is hindered by the technical nature of the demands for grants. The parliamentarians, being laymen, cannot understand them properly and fully. C. The legislative leadership lies with the executive and it plays a significant role in formulating policies. D. The very size of the parliament is too large and unmanageable to be effective. E. The majority support enjoyed by the executive in the parliament reduces the possibility of effective criticism. F. The Financial Committee, like Public Account Committee, examines public expenditure after it has been incurred by the executive, thus they do post-mortem work. G. They increased recourse to guillotine, reduced the scope of financial control. H. The growth of delegated legislation has reduced the role of Parliament in making detailed laws and has increases the power of bureaucracy. I. The frequent promulgation of ordinances by the President dilutes the Parliament's power of legislation. J. The Parliament's control is sporadic, general, and mostly political in nature. K. Lack of a strong and steady opposition in the Parliament and a setback in the parliamentary behavior and ethics have also contributed to the ineffectiveness of legislative control over administration in India. Position of Rajya Sabha. The constitutional position of Rajya Sabha as compared with the Lok Sabha can be studied from the three angles. Number 1, where Rajya Sabha is equal to Lok Sabha. Number 2, where Rajya Sabha is unequal to Lok Sabha. Number 3, where Rajya Sabha has special powers that are not at all shared with the Lok Sabha. Equal status with Lok Sabha. In the following matters, the powers and status of the Rajya Sabha are equal to that of the Lok Sabha. Number 1, introduction and passage of ordinary bills. Number 2, introduction and passage of constitutional amendment bills. Number 3, introduction and passage of financial bill involving expenditure from the Consolidated Fund of India. Number 4, election and impeachment of the President. Number 5, election and removal of the Vice President. However, Rajya Sabha alone can initiate the removal of the Vice President. He is removed by a resolution passed by the Rajya Sabha by an effective majority, which is a type of special majority and agreed to by the Lok Sabha by a simple majority. Number 6, making recommendation to the President for the removal of Chief Justice and judges of Supreme Court and High Courts, Chief Election Commissioner and Comptroller and Auditor General. Number 7, approval of ordinances issued by the President. Number 8, approval of proclamation of all three types of emergencies by the President. Number 9, selection of ministers including the Prime Minister. Under the Constitution, the ministers including the Prime Minister can be members of either house. However, irrespective of their membership, they are responsible only to the Lok Sabha. Number 10, consideration of the reports of the constitutional bodies like Finance Commission, Union Public Service Commission, Comptroller and Auditor General, etc. Number 11, enlargement of the jurisdiction of the Supreme Court and of the Union Public Service Commission. Unequal status with Lok Sabha. In the following matters, the powers and status of the Rajya Sabha are unequal to that of the Lok Sabha. Number 1, a money bill can be introduced only in the Lok Sabha, not in Rajya Sabha. Number 2, Rajya Sabha cannot amend or reject a money bill. It should return to the bill to the Lok Sabha within 14 days, either with recommendation or without recommendation. Number 3, the Lok Sabha can either accept or reject all or any of the recommendations of the Rajya Sabha. In both the cases, the money bill is deemed to have been passed by of the two houses. Number 4, a financial bill not containing solely the matters of Article 110 also can be introduced only in the Lok Sabha and not in the Rajya Sabha, but with regard to its passage, both the houses have equal powers. Number 5. The final power to decide whether a particular bill is a money bill or not is vested in the Speaker of the Lok Sabha. Number 6. The Speaker of Lok Sabha presides over the joint sitting of both the houses. Number 7. The Lok Sabha with greater numbers wins the battle in a joint sitting except when the combined strength of the ruling party in both the houses is less than that of the opposition parties. Number 8. Rajya Sabha can only discuss the budget but cannot vote on the demands for grants, which is the exclusive privilege of Lok Sabha. Number 9. A resolution for the discontinuance of the national emergency can be passed only by the Lok Sabha and not by the Rajya Sabha. Number 10. The Rajya Sabha cannot remove the Council of Ministers by passing a no confidence motion. This is because the Council of Ministers is collectively responsible only to the Lok Sabha, but the Rajya Sabha can discuss and criticize the policies and activities of the government. Special powers of Rajya Sabha. The Rajya Sabha has been given four exclusive or special powers that are not enjoyed by the Lok Sabha. Number 1. It can authorize the Parliament to make a law on a subject enumerated in the state list under Article 249. Number 2. It can authorize the Parliament to create new All India services common to both the centre and state, Article 312. Number 3. It alone can initiate a move for the removal of the Vice President. In other words, a resolution for the removal of the Vice President can be introduced only in the Rajya Sabha and not in the Lok Sabha under Article 67. Number 4. If a proclamation is issued by the President for imposing national emergency or President's rule or financial emergency at a time when the Lok Sabha has been dissolved or the dissolution of Lok Sabha takes place within the period allowed for its approval, then the proclamation can remain effective even if it is approved by the Rajya Sabha alone under Article 352, 356 and 360. The An analysis of the above points make it clear that the position of the Rajya Sabha in our constitutional system is not as weak as that of the House of Lords in the Britain constitutional system, nor as strong as that of the Senate in the American constitutional system. Except in financial matters and control over the Council of Ministers, the powers and status of the Rajya Sabha in all other spheres are broadly equal and coordinate with that of the Lok Sabha. Even though the Rajya Sabha has been given less power as compared with the Lok Sabha, its utility is supported on the following grounds. Number 1. It checks hasty, defective, careless, and ill considered legislation made by the Lok Sabha by making provision of the revision and thought. Number 2. It facilitates giving representation to eminent professionals and experts who cannot face the direct election. The President nominates 12 such persons to the Rajya Sabha. Number 3. It maintains the federal equilibrium by protecting the interest of the states against the undue interference of the centre. Parliamentary privileges. Meaning, parliamentary privileges are special rights, immunities, and exemptions enjoyed by the two houses of parliament, their committees, and their members. They are necessary in order to secure the independence and effectiveness of their actions. Without these privileges, the House can neither maintain their authority, dignity, and honor, nor can protect their members from any obstruction in the discharge of their parliamentary responsibilities. The Constitution has also extended the parliamentary privileges to those persons who are entitled to speak and take part in the proceedings of a House of Parliamentary or any of its committees. These include the Attorney General of India and Union Ministers. It must be clarified here that the parliamentary privileges do not extend to the President, who is also an integral part of the Parliament. Classification. Parliamentary privileges can be classified into two broad categories. Number 1, those that are enjoyed by each House of Parliament collectively. Number 2, those that are enjoyed by the members individually. Collective privileges. The privileges belonging to each House of Parliament collectively are: Number 1, it has the right to publish its report, debates, and proceedings, and also the right to prohibit others from publishing the same. The 44th Amendment Act of 1978 restored the freedom of the press to publish true reports of parliamentary proceedings without prior permission of the House, but this is not applicable in the case of a secret sitting of the House. Number 2. It can exclude strangers from its proceedings and hold secret sittings to discuss some important matters. Number 3. It can make rules to regulate its own procedure and the conduct of its business and to adjudicate upon such matters. Number 4. It can punish members as well as outsiders for breach of its privileges or its contempt by reprimand, ad- admonition or imprisonment, also suspension of expulsion in case of members. Number 5. It has the right to receive immediate information of the arrest, detention, conviction, imprisonment, and release of a member. Number 6. It can institute inquiries and order the attendance of witnesses and send for relevant papers and records. Number 7. The courts are prohibited to inquire into the proceedings of a house or its committee. Number 8. No person, either a member or an outsider, can be arrested, and no legal process, civil or criminal, can be served within the precincts of the House without the permission of the presiding officer. Individual privileges. The privileges belonging to the members individually are: number 1. They cannot be arrested during the session of Parliament and 40 days before the beginning and 40 days after the end of a session. This privilege is available only in civil cases and not in criminal cases or preventive detention cases. Number 2. They have freedom of speech in Parliament. No member is liable to any proceedings in any court for anything said or any vote given by him in Parliament or its committee. This freedom is subject to the provision of the Constitution and to the rules and standing orders regulating the procedure of Parliament. Number 3. They are exempted from jury service. They can refuse to give evidence and appear as a witness in a case pending in a court when Parliament is in session. Breach of privilege and contempt of the House. When any individual or authority disregards or attacks any of the privileges, rights, and immunities either of the member individually or of the House in its collective capacity, the offence is termed as breach of privilege and is punishable by the House. Any act or omission which obstructs a House of Parliament, its members, or its officers in the performance of their functions, or which has a tendency, directly or indirectly, to produce results against the dignity, authority, and honor of the House, is treated as a contempt of the House. Though the two phrases breach of privilege and contempt of the House are used interchangeably, they have different implications. Normally, a breach of privilege may amount to contempt of the House. Likewise, contempt of the House may include a breach of privilege also. Contempt of the House, however, has wider implications. There may be a contempt of the House without specifically committing a breach of privilege. Similarly, actions which are not breaches of any specific privilege but are offences against the dignity and authority of the House amount to contempt of the House. For example, disobedience to a legitimate order of the House is not a breach of privilege but can be punished or contempt of the House. Sources of privileges. Originally, the Constitution Article 105 expressly mentioned two privileges, that is, freedom of speech in Parliament and right of publication of its proceedings. With regard to other privileges, it provided that they were to be the same as those of the British House of Commons, its committees and its members on the date of its commencement, that is, 26 January 1950, until defined by Parliament. The 44th Amendment Act of 1978 provided that the other privileges of each House of Parliament, its committees, and its members are to be those which they had on the date of its commencement, that is 20 June 1979, until defined the Parliament. This means that the position with regard to other privileges remains same. In other words, the amendment has made only verbal changes by dropping a direct reference to the British House of Commons without making any change in the implication of the provisions. It should be noted here that the Parliament till now has not made any special law to exhaustively codify all the privileges. They are based on 5 sources, namely constitutional provisions, various laws made by the Parliament, rules of both the houses, parliamentary conventions, and judicial interpretations. Sovereignty of Parliament. The doctrine of sovereignty of Parliament is associated with the British Parliament. Sovereignty means the supreme power within the state. That supreme power in Great Britain lies with the Parliament. There are no legal restrictions on its authority and jurisdiction. Therefore, the sovereignty of Parliament, parliamentary supremacy, is a cardinal feature of the British constitutional system. According to A.V. Dicey, the British jurist, the principle has three implications. Number one, the Parliament can make, amend, substitute, or repeal any law. D. Lolme, a British political analyst, said the British Parliament can do everything except make a woman a man and a man a woman. Number 2. The Parliament can make constitutional laws by the same procedures as ordinary laws. In other words, there is no legal distinction between the constituent authority and the legislative authority of the British Parliament. Number 3. The parliamentary laws cannot be declared invalid by the judiciary as being unconstitutional. In other words, there is no system of judicial review in Britain. The Indian Parliament, on the other hand, cannot be regarded as a sovereign body in the similar sense, as there are legal restrictions on its authority and jurisdiction. The factors that limit the sovereignty of Indian Parliament are: Number 1. Written nature of the Constitution. The Constitution is the fundamental law of the land in our country. It has defined the authority and jurisdiction of all the three organs of the Union government and the nature of interrelationship between them. Hence, the Parliament has to operate within the limits prescribed by the Constitution. There is also a legal distinction between the legislative authority and the constituent authority of the Parliament. Moreover, to effect certain amendments to the Constitution, the ratification of half of the state is also required. In Britain, on the other hand, the Constitution is neither written nor there is anything like a fundamental law of the land. Number 2. Federal system of government. India has a federal system of government with a constitutional division of powers between the union and the state. Both have to operate within the spheres allotted to them. Hence, the law-making authority of the Parliament gets confined to the subjects enumerated in the Union list and concurrent list and does not extend to the subjects enumerated in the state list except in 5 abnormal circumstances, and that too for a short period. Britain, on the other hand, has a unitary system of government and hence all the powers are vested in the centre. Number 3. System of judicial review. The adoption of an independent judiciary with the power of judicial review also restricts the supremacy of our Parliament. Both the Supreme Court and High Court can declare the laws enacted by the Parliament as void and ultra vires unconstitutional if they contravene any provision of the Constitution. On the other hand, there is no system of judicial review in Britain. The British court have to apply the parliamentary laws to specific cases without examining their constitutionality, legality, or reasonableness. Number 4. Fundamental rights. The authority of the Parliament is also restricted by the incorporation of a court of justiciable amendments rights under Part 3 of the Constitution. Article 13 prohibits the state from making a law that either takes away totally or abrogates in part a fundamental right. Hence, a parliamentary law that contravenes the fundamental right shall be void. In Britain, on the other hand, there is no codification of justiciable fundamental right in the Constitution. The British Parliament has also not made any law that lays down the fundamental rights of the citizen. However, it does not mean that the British citizen do not have rights. Though there is no charter guaranteeing right, there is maximum liberty in Britain due to existence of the rule of law. Therefore, even though the nomenclature and organizational pattern of our Parliament is similar to that of the British Parliament, there is a substantial difference between the two. The Indian Parliament is not a sovereign body in the sense in which the British Parliament is a sovereign body. Unlike the British Parliament, the authority and jurisdiction of the Indian Parliament are defined, limited, and restrained. In this regard, the Indian Parliament is similar to the American legislature known as Congress. In USA, also, the sovereignty of Congress is legally restricted by the written character of the Constitution, the federal system of government, the system of judicial review, and the Bill of Rights. The theoretical portion of this chapter ended here, but this chapter contains too many tables regarding different parliamentary functions or committees. So for further tables, you can refer the book or the PDF. Thank you so much.